Allow me to introduce Mr. Ankur Garg, partner Lakshmi Kumaran and Sridharan attorneys. A registered patent agent, Ankur offers a comprehensive IP advice. His expertise spans quantum computing, AI, machine learning, and more. Can I invite you to the dais? And the fellow panelists, Lakshmi Devi Somnath, partner Surana and Surana, Dr. Shraddha Damle, in-house IP counsel, Jet Synthesis, Harshit Saxena, legal counsel, Geo Platforms Limited. Yeah. So Rohan Ahuja, associate partner, Intel advocate. So I'll just introduce the moderator, Ankur Garg. He's a registered patent agent, IP attorney. He offers a comprehensive intellectual property advice with a background in information and communication technology. He has excelled in patent drafting and prosecution since 2010, specializing in quantum computing, AI, machine learning, CRIs, telecommunication, automotive electronics, and wind energy. He conducts IP seminars globally and collaborates with in-house counsels from Japan, US, and Europe. So I hand over the session to you.
So thank you for the introduction. Today we are actually going to discuss about online gaming, various different aspects of online gaming, and what are the various different IP issues and challenges related to online gaming. The panel that we have today, I have Dr. Shraddha Damle with me. She is IP head at Jet Synthesis Private Limited and handles their entire IP portfolio in India and globally. She's been working in the field of IPR for more than 15 years. Dr. Shraddha, she is a well conversant not only in the field of patents, but also handles copyrights, trademarks, industrial designs laws. Her company, Jet Synthesis Private Limited, is a Pune-based company which has various verticals focusing on gaming, esports, mobile application, and music. Welcome, Shraddha. Next panelist we have is Rohan Ahuja. He is an associate partner at Intel Advocare. Rohan is an alumnus of Faculty of Law and has over 12 years of experience in handling complex and multi-jurisdictional disputes pertaining to intermediary liability, data protection, IP violations, gaming advisory, and corporate law. Rohan has worked across industries and has extensive experience in various corporate and legal issues and has extensively focused on IP challenges within the online gaming sector with a special focus on fantasy sports. Welcome, Rohan. Next we have Lakshmi Devi Somnath. She is a partner at Surana and Surana. I don't think she needs a formal introduction. She is an alum of NLSIU, Bangalore. She has served as a member judge at IPAB and has been a part of adjudications in numerous IP cases. Welcome, ma'am. And finally, we have Harshit Saxena. He is the legal counsel at Geo Platform Limited. Harshit is a legal counsel with 10 years of experience in the industry and is currently working with Geo Platforms to manage their legal ecosystem of gaming division. He ensures resolution of corporate data privacy, commercial compliance, and regulatory issues. Harshit has extensively worked on B2B, B2C transactions, blockchain technology licenses, cloud services, etc. And his day-to-day role entails ensuring smooth functioning between strategy and planning, engineering, product finance, commercial human resource labor, information security, business marketing, direct and indirect tax teams. When he's not doing the above said functionalities, he has said that he likes to play percussions in a parent's band at his kid's school. That's really nice to know, Harshit. Now, coming to the topic of online gaming, I am sure a lot of us have played video games in the past. I come from the time when we used to play Mario, Contra, and then we moved to Age of Empires, and nowadays it is no longer Mario, Contra anymore. People are on esports, they are in fantasy gaming, all sort of things. So let me hand over the mic to Dr. Shraddha Damle. She would actually walk us through various different evolution that has happened in the gaming industry and what currently is the trend when it comes to the entire online gaming industry.
Yeah. Thank you, Ankur. I understand this is a post-lunch session. So I decided to start it with few videos which can give you hands-on experience what exactly we will be talking about. So there are two videos that I will be showing you right now. One is about esports and one is about what exactly mobile gaming is. So can I have the video? Yeah.
कोई नहीं मुकाबला from the bottom निकला टॉप डाला पैसा तो मुनाफा माँ पे गाली सीधा लाफा और रैप नाका सुनते बांग्ला मुझे भाता मैं streams हो या teams अब पूरा कामयाब मैं गोली वाला माइंडसेट और धोनी जैसा शाप मैं हर पब में जी और गेम है मेरे हाथ में हंसता सीधा बैंक तक 50 वाले लाफ में हा 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 भाई तू है पीक और मैं लेता हफ्ता अब खुद के तेरे अपनी तूने रखा चमचा पूरा गैंग क्राइमी कवर टॉप सीधा शॉट शॉट तेरे ब्रेन में बॉम्बे दा बैड मुंडा पंजाब तक एंड में कमेंट वाइन पर बंदा नहीं हुसैन में रिक्शा से निकला ओवर मेरे रेंज में बैक बेंच वाले लड़के आए फ्रंट पेज पे सड़क के महारानी के बेस में मैं संजू बाबा वॉक करता हाथ रख के जेब में देख ले खलनायक में और तुझे वाला फ्रैक्चर तेरा टैंक और मैं एम्बुलेंस में पहुंचने वाला
Yeah, so this was a mobile game. That's a real cricket game. Now we'll be discussing various aspects of IP. Now you saw the team names which is there. So these were actually the same on the lines of IPL. We had 8 teams. Then we will discuss about the various IPs that are involved. First I'll show one more video. Yes.
Namma Bangalore, Namaskara, how are you guys doing? This is Sky Sports Championship 5.0, brings you live action right here in Koramangala Indoor Stadium. शट डाउन किया जाएगा वीगॉट के द्वारा एक आखिरी रैंगल, एक आखिरी सर्कल, एक आखिरी फ्लाइट पाथ, ये सब डेफिनेटली देखने को मिलेगा. So ladies and gentlemen, boys and girls, are you guys ready? Are you guys excited for the final game? The champions team blind!
Yeah, you can keep this slide. So these were the 2 different aspects. Now first video which we saw was just a mobile game which you as a single player can play. But when these mobile games are played in a competitive sports environment, in an arena which is specially created for it, it may be single player or a multiplayer, it takes a form of esports. So the second video was esports. So basically I wanted to show what are the possible things that may be coming at today and in future as well. Now when we see a game, just like a real game, there are multiple aspects of IP which are involved. Now the arena can be different aspects of copyrights. Then there can be game consoles which can be part of patents. There are logos, there are then the role of play. It can also be copyrighted. Technology and gadgets are there, titles are there, music is there. So I feel that game is more like a movie, okay, where there are multiple stakeholders. Okay, it is not just one game which is released, but there are multiple stakeholders. Now, the reason for mentioning is because the multiple stakeholders are there. You have to take appropriate NOCs from each stakeholder when it comes to IP. So it becomes very difficult to coordinate with all, where the agreements play very important role considering IP. Next slide, please. So this is not only the traditional IP that we should focus on. Considering the emerging technology that is taking place right now, there is brand extension, okay? Now it is not limited to the traditional form of IPs, but NFTs are the future IPs. So a feature which is there in my game, I can make an NFT out of it. So this is a future of brand extension that we definitely we need to consider. Second. So as I told, there are multiple stakeholders in IP. There are developers, broadcasters, designers, content creators. So you have to actually have a proper agreements with them with regard to, so that there are no further issues with regard to IP ownership. So this is basically to give the overview that currently there is $1 million business in esports. Where there is more money involved, more IP is generated, because all this is an IP game. So considering the importance of this, now this has evolved as a totally different ecosystem. So here there are multiple sponsorship, advertising, media rights. So other aspects other than IP are also taking place in this particular vertical. I don't know if all are aware of this. Olympics is considering including esports in future. So they have almost constituted a committee. Asian Games have already started with esports. So my focus over here is that esports is growing as a serious business. Now if you say that someone is a gamer, that is a professional career. It is no more just for passing time that one is playing game, but it is emerging as a different professional option also. Next slide. So basically, my initial role was here to just introduce and get feel of all the IPs, basic introduction to the IPs. Now I guess my co-panelist Lakshmi will touch upon the other aspects.
So, thank you, Shraddha, for actually showing that very interesting video. And this actually tells us that it is no longer a recreational aspect where we sit for 30 minutes, 45 minutes, play a video game and get relaxed. It has actually been commercialized and being played at such a large scale that it has been sponsored, the various events are being conducted, and it has completely transformed into an industry where various different stakeholders and players are coming into play. We've also touched upon various different IP aspects that go into a game. Rohan, he has been in the industry for quite some time and has been advising various different clients specifically with respect to IP challenges in the gaming industry. So I would request you, Rohan, to touch upon various different challenges that come across the gaming industry, and specifically because you're focused on fantasy gaming.
Yeah.
If you can talk about that, that will be helpful.
Thank you, Ankur. So just giving a brief background what Dr. Shraddha gave. So basically, with the rise of technology and internet connectivity, we have seen the surge in the gaming industry. More so post-pandemic, this has accelerated the growth. So now, with the acceleration of growth, creates more demand within the sector itself. So now, creation of demand has led to increase the game developers, the competition has increased, whereby embracing novel innovations within the industry. So when it talks about novel innovations, we talk about IP strategies, IP, intellectual property protection, that is required. So now we have been seeing it when a game is just not about one normal, what was a real event game. So game, when it's a computer game, you have a lot of elements to it. There might be game concept, there might be title, logos, lot of arena, what Dr. Shraddha pointed out, arenas. So all these are entitled to protection under the as intellectual property. So on basis that so that to ensure preventing of any misuse of the brands and dilution of the brand identities and the game itself per se, that is very important. So now when we talk about the challenges, firstly it's the trademarks. So in routine, gaming companies obviously secure trademark registrations for their game titles, logos, players, characters, everything. But additionally, when we talk about real money games, so real money games cannot, where the monetary aspect is involved, consideration is involved. So trust becomes a very important factor. So when we're talking about trust, so what is important? Trademark registrations help us in securing that trust, ensuring the users can basically resonate with the games they are engaging in. That is what when it comes to trademark registrations. So it further helps in preventing any dilution of brand identities that is there. Let's take it further when we go to copyright. When copyright is there are various elements of a game. Obviously, that includes game notes, computer program, a computer game obviously has a computer source code behind it, titles, characters, artistic elements, graphical representations, user interface. So all those things are entitled to potential copyright protection. So for that, I think it is very essential for any gaming company to ensure that they secure registrations, and just not with respect to one element, but with respect to all the elements of the game. So that is what, say. So when Ankur had pointed out, so basically the new hot topic these days is the fantasy sport. So what is fantasy sport? So fantasy sports basically traces its roots back to 1960, when there was basically a group of baseball enthusiasts who had come out with the first known game, fantasy sports league of baseball, known as Greater Oakland Piggyback Baseball League, so which was there. From that, we have come a long way with the advancement of technology. Now we are in the 21st century. We have seen with the connectivity, accessibility to smartphones, we have almost 300 fantasy sports games that are registered in India, and 18 crore users who are playing those fantasy sports. So that is one of the most important things that is there, that it has exploded considerably in last few years, what we have seen. So, so basically, when we are talking about fantasy sports, what is it? Law supports, in India, law supports the operators of these fantasy sports. However, what we feel which affects the marketability of the gaming industry and the players who are involved in that games. So that is what it has to be seen. When we see a recent judgment of the Delhi High Court, the Delhi High Court was adjudicating an issue of playing cards of players, which was being adjudicated. The court, while declining the reliefs, had injunctive relief, told that the players cannot, the information which is available in the public domain cannot be exclusively licensed to third parties. So per se, vis-a-vis the personality rights of those players, when the information is already available, cannot be licensed. So that was which is pending in appeal, obviously now. We are aware of it. So now this is the issue which has been recently coming up, and is not restricted only to now fantasy sports, not only restricted to your images and player images and logos. Now it has expanded. Now we have been seeing a lot of cases and issues that are arising with respect to increase in the broadcasting events of cross-jurisdictional where the lot of sporting organizations have started to issue notices and sending to protect their rights, general rights with respect to the team jerseys, event names, player names, leagues, all those things. So there's been a considerable development that has taken, which I feel that gaming companies have to be cautious now when it comes to fair use defense that is generally taken in such cases. So that is what I feel. It's an evolving jurisprudence. I think it'll take some more time. We'll have more clarity on it when it comes to fantasy sports. So, thank you.
You're absolutely right, Rohan. And specifically with respect to gaming industry, there are different IP rights, like that has been pointed out. May it be game design, may it be copyrights, may it be trademarks, may it be digital right management with respect to ensuring that the games are not pirated. But all of these rights are only protected to the extent that they can actually be protected by the court of law. So there are various different jurisprudences that have come along, various different case laws. I think there's nobody better than Lakshmi Devi who can actually focus on this and tell us about what is the jurisprudence that has evolved in the field of online gaming. So I would request you, ma'am, to talk on that.
Thank you, Ankur. So we have a lot of gaming characters here. All of you who are familiar with gaming may have come across most of these characters during your gaming sessions. One is Mario, that who Ankur mentioned. So the Mario copyright is there up to 2080, and until then they can restrict any infringement of the intellectual property upon Mario, the character, its merchandise, all aspects of intellectual property covering that particular character. You also see various other characters here. Now, from where exactly does the intellectual property stem regarding this protection? We do not have a separate law as of now. Neither do we have separate rules framed. So we need to derive whatever protection we can from the existing legislation. So if you look at the Copyright Act, Section 2, so 2O defines literary work. It defines literary work to include computer programs and computer databases, thereby covering the source code that underlies every game that is developed for play. So when there is a game developed, there are various people behind the scene. For example, producers, creative directors, also designers, people who have brought in various elements into the game. There are employees who are contracted by the particular company to work for them. Of course, all intellectual property that they create ultimately resides in the company. So all the monetary benefit that codifies the intellectual property that can be claimed by the developer of a game. Then we come on to Section 2J of the Patent Act, which again allows for any software programs that have an inventive step and that are a technical advancement to be protected in the country. We also have the Designs Act, Section 2D, which allows us to protect the design, the composition, the layout of the particular game, probably various panels. This is especially important because there have been cases, there has been a case not in India, but in the US regarding whether screenshots, the ownership over screenshots can be claimed by one of the players who took that particular screenshot, or whether the copyright in that vests in the developer rather than the player who took it. So that is Section 2D of the Designs Act. Now, all that being said, we come to what IP would vest in the various aspects of the game. As Shraddha has already elaborated in detail, it's various things. For example, the brand, the character, the role play or the gameplay, as gamers would like to say, everybody has their own signature gameplay. In an interactive game, the way you proceed from level to level of the game defines your gameplay. So that is a very important aspect where there is a gray area as to who exactly is the author of the gameplay, whether it is a developer who facilitates the scenario whereby a gameplay can be developed, or whether it is the player who by his own skill and own maneuvers develops a particular set of movements whereby he proceeds from level to level in a game. So all these are gray areas. Now, if you look at this particular case, Nova Productions versus Mazuma Games, 2006 case, where this was in question. It was a pool game, and there was a screenshot taken by a player of this frame in the game. Now, who would be the owner of the copyright in this game? Would it be the player who took the screenshot? He's playing the game. As he plays the game, he takes a screenshot of the game as it lies before him. He would have probably posted it on social media. He would have, advertised his expertise in the game to his set of fellow gamers. So this was taken by him. And he claimed an ownership over this particular screenshot. However, the court went on to say that the person who developed the game, that is who enabled the user of the game to create this. I mean, he could not have created if not for the developer. So the person who helped him, who enabled him to do that, would be the owner of the copyright and not the player. And the words that were used by the court, the particular words are, the English law provides, the author shall be taken to be the person by whom the arrangements necessary for the creation of the work are undertaken. According to the court, in that particular case, the arrangements necessary for the work to be done was the developer of the game, not the player. And therefore, the copyright was vested in the developer of the game, not the player. Now, this is a case that most of you might be familiar with already. Herms versus Rothschild, dealing with NFTs. Now, in this particular case, what you see there are various Hermes Birkin bags that have a lot of patterns on them. They have fox fur and they have various patterns, stripes, polka dots, animal prints. These bags were developed as NFTs during a game, and the question was who owned the rights in it. Almost 100 NFTs were developed during the course of the game. Question was whether there was an infringement due to the development of this particular digital bag. Again, the court held in favor of the owner of the particular design and held that it would be an infringement to develop NFTs that would violate that particular design. So, over and over again, we notice that the trend goes in favor of the holder of the IP or the developer of the game. That's what the trend has been. Now, Grand Theft Auto is another very popular game. I'm sure most of you must have played it. Grand Theft Auto 5, that was the version in question here. Grand Theft Auto versus Rockstar Games. You see Lindsay Lohan. Now, is there any character that you see in there that resembles her? You do? Okay. That's what she claimed, that one of the characters there, the blonde, resembled her and it was based on her. It exactly looked like her, especially one of the versions that the particular get-up and the look of the character in one of her movies. She claimed that the character in Grand Theft Auto 5 looked like her. This is a case of violation of personality rights, which was also discussed earlier in one of our sessions. So, question is, who won this particular case? Who do you think it would be? Would it be Lindsay Lohan, who clearly has rights to her depiction in any particular form, in digital media or print or visual form? It is she vis-a-vis the developer of the game. So, who do you think would have won the case? Yes, it is the developer of the game again, because the court found that the character could not be seen to have violated her personality rights, since the fact that she and the character there are a look-alike is very far-flung, and it was just a character that was developed in the game, not based on Lindsay Lohan, and therefore she failed to succeed in that particular case. Now, this particular case that came before the Honorable Delhi High Court, Sony Computer Entertainment Europe versus Harmeet Singh. You see these stores in various pockets in Delhi, where if you go there, they would deconstruct your PlayStation and allow you to purchase a much cheaper variant of the gaming console. Now that was in question over here. I think PlayStation 5 was in question in this game, where the entire series of PlayStations had been developed by the company, but the gaming console and the programming had been decoded, and a much cheaper version was made available to the consumer by this particular store and certain other stores. So in this case, the question of the patent in that particular invention, the game behind the game, was called into question, also the design behind the console. And the court very clearly held that what was happening was a clear case of infringement and hauled them up for this particular case of infringement. Now, in Blizzard Entertainment, this is a very popular game, WOW, World of Warcraft. Now, in this particular case, there were various versions made of the World of Warcraft by the people who were playing the game. There were opportunities where you could develop a character, model a character based on how you wanted the character to be depicted. As Shraddha said, you could probably choose the way in which the character was dressed. You could choose various other aspects of the character. And the question was whether all this could be protected, and whether the softwares behind the game are copyright protected, or whether the copyright as developed on the players' machines would constitute some work that involved human element, creative element, and could be protected. The US court very clearly held that there is an element of infringement, and that the player of the game could not claim individual copyright over such games. Tata Sons Limited versus Greenpeace International. I don't know how many of you have heard of, yes, this particular case. Pac-Man. You see a turtle there. He's not very visible. He's in green against a white background, but he's right there. This is a game modeled on the Pac-Man game by Greenpeace International in order to increase the awareness about the lowering population of turtles. And what happens is, instead of Pac-Man, you have these characters that look like the Tata logo coming in and trying to chomp the turtle. Yes. So whether this is a violation of Tata's trademark over its logo, it is very clearly, I don't know if it was an accidental similarity with the Tata logo, but it looks. Yes, correct. So the court held that the logo could not be used and that it would be an infringement of the logo. Greenpeace was very clear that this was simply something that they did in order to get across their message, but then they were stopped from using that particular logo. Now, if you look at the law in India, as I said when I started, the law is not codified yet very concretely and solely as applicable to gaming, including online gaming. How many of you saw the movie, Donkey? Not yet. For the uninitiated non-Indians here, we have this famous movie star called Shah Rukh Khan, who is the first in that, the person walking. So this is one of his movies. This is a scene from his movie. They are crossing borders from India to reach London through various territories without a passport. That's the premise on which the movie runs. And they don't have anything legitimate about it. They do not have any ground rules. They do not have anything. They just need to cross from territory to territory, braving all the hazards and anything that might befall them. This is kind of the scenario of online gaming right now. So unless there is a particular set of rules that is not framed concretely to define what online gaming is all about, what happens regarding ownership of derivative IP that emerges out of a game. Of course, it is developed on the platform that is provided by the developers, but there are certain stages where the IP that is developed seems to be a work much more creative than the platform on which it was developed, and for which some ownership rights can probably be attributed to the players or the person who developed them. So concrete laws need to come up regarding this scenario, until which it would be a bleak landscape as you see here. And that's it. Thank you. I think Harshit would now be focusing on more about what I concluded on the legislation.
Thank you, Lakshmi, for giving that insight about various different case laws and how the IP created by the developers is actually being protected by different courts. Now, Harshit has been working with Geo platforms, and Geo Games is an upcoming platform that provides various different opportunities to different gaming apps and allows various different gaming apps to be hosted. Harshit, in view of these case laws, how has been your experience with respect to the laws that are currently in India or outside, whether they are providing protection with respect to various different aspects of IP of online gaming, and if there is any lacuna or there are some changes required from your own perspective and experience, can you share with us that?
Hello everyone. So I'll give you a brief introduction about what Geo Platforms is. It's basically a one-stop shop for all sorts of gamers. So you'll find casual games there, people who just want to pass time between catching two metros, or it's for professional gamers who want to participate in esports. So there are various sponsored activities which are conducted along with other like-minded business bodies. Then there can be scenarios wherein you can stream. If you are a professional gamer, you can stream. So there's Geo Games Watch, wherein you can watch how professional players are playing. So there are various aspects to it. So obviously, this is a pretty exciting time for the online gaming industry, primarily for two reasons, I would say. Number one being the extent of technology, Web 3.0, the endless possibilities that it has brought about. And secondly, India being the second biggest market in terms of users, has started finally spending money on online games. So compared to previous times, now 1 in every 5 guys is spending money on online gaming, Indians. So which has led to a threshold shift in terms of users, in terms of user engagement. There are scenarios, so that is why it has become quite an exciting time. As far as the challenges are concerned, see, as I was discussing with you earlier, so there are two sorts of nations how I would broadly divide the current scenario. So there's one like China and South Korea, who had recently, China had recently, I believe last week itself, they had issued certain regulations wherein they are saying that we will even decide the amount of time that end users are participating or consuming online games. We will also decide the days on which kids can play online games. So the kids are not allowed to play more than 3 hours. They are only allowed to play on weekends. That is the level of involvement that the regulatory bodies are getting into, which in my personal opinion is getting too much into the personal space of an end user. On the other hand, we have nations like India, US, Japan, who are kind of stuck in a stage of wait and watch. Let's see how the industry is addressing the regulations that we are bringing about. So India, for example, let's say, we have recently seen this 28% GST implication being imposed. In my personal opinion, the challenge is that the government bodies, not just in India, but across the world, they are addressing games as in one whole set. They are not distinguishing it properly. So broadly speaking, apart from the various genres that Ankur had mentioned, there can be, broadly speaking, there can be 3 categories: online sports, esports, and fancy sports, or one more if we can add to it, wherein we are gambling. So what the current situation is dealing with is that everyone is being brought under one particular basket itself. So even if you are someone who's only playing PUBG for the entertainment purpose itself, you, or whatever earnings you might have because of that, that would be charged on the same parameter as someone who is gambling. The intent of 28% GST was to discourage gambling. It is obviously the government does not intend to discourage people from playing online sports. So that is where probably government needs to address these aspects in terms of identifying who is doing what, and taking necessary steps to distinguish between that.
Right, Harshit. I think that's a good point, that all the various different rules or GST taxes that are being imposed on different games, because the platforms are different, the manner in which the games are played, they are different. They should not be covered under one umbrella. And this is one aspect that the government can look into, specifically the rules. And one specific point that's very interesting that you brought up is China and South Korea, they are actually implementing time rules on kids or various different users that when can they play, for how long can they play. I think parents in this room would be happy to hear this and say that yes, my kids can only play 2 hours, that would be good if the government can regulate that. But it's a good thing that India has probably not done that yet. I'm not sure if that particular regulation is.
I believe that the regulation that I have just referred to, it was brought about a week back, and the particular officer in China who had brought this about has been told to shift to a different department now. So I believe even China is not going to go ahead with such a regulation, but this is the level of development that has been going on in terms of regulation. So
that's really interesting, Harshit. So with respect to the games that are being developed, I see that there are big players in the industry who are developing games that are being played worldwide. At the same time, I see that because India is a growing ecosystem where there are a lot of startups who are building up games, bringing up new concepts. From a startup point of view, Shraddha and Harshit, because you are directly working in this space and you have been interacting with these startups and probably maybe you have taken over certain startups. What is the advice that you would give to a startup in terms of their IP building? Would you suggest to them to build their own IPs or to license third-party IPs and launch their products as soon as possible? What would be your advice in this area?
So I'll touch upon it in 2 ways. So see, startups, as of now, in my personal opinion, see, this is a time wherein technology has enabled development of game once the concept is ready quite easier. Compare it to, let's say, a scenario wherein endless runner games like Subway Surfer and all these, there are many such games in the industry now. The background for it starts from 1980. So for this particular genre to develop, it took us almost 30 years, probably more than that, to reach to a stage wherein now we have Subway Surfer and all those games. So startups need to identify, on the other hand, startups now can readily develop a concept based on a popular genre that they see going about. So let's say, for example, Wordle. When we saw Wordle coming into picture, within a span of 1 week, we had multiple duplicate copies of Wordle who were engaging with users. So the USP of Wordle was lost within a span of 1 week. Why? Because AI enables, the Web 3.0 enables developers to create a similar game within a span of a couple of hours, if not days, because of the technology. So the startups, what they need to do, as soon as they develop a unique model which they believe is gonna be a selling point for them, they need to protect it in such a manner that the cost of protecting it is not so escalated that it becomes a loss for them in the longer run. Because in any case, within a span of few weeks, if not months, if they're a viral game per se, they would have endless number of competitors competing for the same space. If you would like.
Yeah, so with regard to startups, now 2 videos which I showed you right now, okay, one was esports, so that vertical is Sky Sports, it is, the company name is Sky Sports, and the second game which I showed was real cricket, that is Nautilus. Now to your information, both were startups, okay, when we acquired them. So a startup actually, they had a good IP, so that was, but yes, the awareness level is not as much as required because the basic filings were also not in place. The game was really good, but basic filing as to trademarks. Now there are hardly any patents and other IPs here. It is more about trademark and copyrights. But basic due diligence, like you need to have whichever logos which you are showing in your game. Okay, you should not infringe on third-party IP also. So there are basic guidelines that we need to follow. For example, the cricket game which I show, we have to follow BCCI and ICCI guidelines because there are certain guidelines which are provided by them and we cannot infringe that. So there are few aspects which as a startup they might not be knowing about, but when they are acquired by a big entity, then all the headache comes to us. So yeah, but as a startup, they are not aware. And basic filing also, even the trademark filing was also not properly done. So yes, there is an area of improvement. And with regard to other thing is that these IPs basically, they are basically not aware what are the avenues that can be protected. So there are many things like arena. So many a time, not only now since we are aware of it, but there are many startups which are actually not aware, okay, this can also be protected as a form of IP, that how to play a game. If it is unique, yes, it can be protected. There are certain softwares that can be patentable aspect or a copyright depending on what is subject matter. So yes, the level of awareness, if you ask me, it is totally low. But actually nowadays some startups are very smart, and in fact they are sometimes in a better negotiation, what you can say, position, and they smartly negotiate. And when you were talking about the derivative works, that comes. So most of the time it is taken over by the company which takes up. So most of the time it is the agreements and the contracts in which there is a clause itself that any derivative work that will be generated will be owned by the company which has taken it over. So I guess this fight is same like a movie. That's why I gave the analogy of the movie, where even the screenwriter is fighting for his right, a singer is fighting for the right, and the producer is owning multiple rights. So that's why I think that somewhere it is same like a film industry. There are multiple stakeholders and it is owned by someone else.
Harshit and Shraddha, you also mentioned that when a startup is actually building a game, there may be times that the game actually goes viral. And this particular aspect for a game to go viral is not always intended or promoted by that particular gaming platform. And sometimes what happens, which is also a trend nowadays, that various different YouTubers or various different streamers, what they would do is they would record a session of their game while they are either playing the game, or they would analyze the game to provide their critique comments, or talk about the techniques, the manner in which the game can be played, or talk about various different hacks that can actually be employed for that game. Now, when these streamers or YouTube channels, they actually take a certain content of the game, is it a concern for the gaming company? Is it considered as a copyright or design violation, or is it something that is taken in a positive spirit to say that yes, the brand value is essentially increasing and it is giving positive, if it is giving positive feedback to the platform, it's actually not bothered about?
Yeah, as we say, every coin has two sides. So the influencers, yes, they are sometimes nuisance to us, and at times they are beneficial to us. So see, nowadays the platform, like even the YouTube is quite active in taking action if the subject matter is trademark or copyright which is protected, and if you notify them, they are actively taking action against any grievances. So even at a YouTube level, certain things can be resolved. For example, if your logo or certain aspects of a protected IP, okay, the question is that your IP should be registered, because YouTube take action only when you show some registrations. Otherwise, they will not take any action unless there is a court order. So yes, there are platforms which are taking impromptu action, provided you notify them. With regard to the influencers or YouTubers making videos, see, they will not bother us unless and until if it's affecting my viewership. So if it is having negative impact, and if I see there is a lot of movement on the negative side which is going because of a particular YouTuber or influencer, I can definitely, we have to take, but till today we didn't have to take any such actions. In fact, the events which I showed you right now, the top row was, like front row was occupied by all influencers and YouTubers. Rather, they were invited by us. Why? Because they have a lot of followers. So when they post our content on their channel or handles, whatever you mention on social media or YouTube, it gives us more, what you can say, viewership. I get more reach because of them. So nowadays, influencers are like celebrity to us. And we have to take care. Like recently, when one of our event was concluded, I was attending that just to take a feel, because even this feel was new to me. So I was like, who is that person? Oh, he's a celebrity. He's like more than, there were 12 bouncers who were escorting him. And he came like from the grand car, and I was like, who is he? He looks so ordinary. No, he's a big, I cannot take his name, but he's a big YouTuber. And I saw, then I go and I like went and checked out, okay, he had photographs with Virat Kohli and all the top cricketers. And then I understood he's a YouTuber. He just plays the game and gives some analysis and feedbacks. So you see, this is also one of the emerging field, okay? These influencers, they just post about your games and your products, and it helps us rather. Till today, it is helpful.
Right. So, considering different aspects of IP protection that are provided to online gaming, the challenges that we have, Rohan, you've been practicing in this area for quite some time. In terms of a holistic IP protection that needs to be provided to either a gaming platform or to a developer, what, as an advice, would you provide to that person in this particular area?
Yeah. So what I feel is that the protection has to be a 360-degree protection, where it is a multi-dimensional protection which has to be carried out by the gaming companies to ensure it just cannot be one element of the game which can be protected, be it trademark, copyright, patent, whichever. It has to be protected in all the manners so as to deter any misuse of the IP. So this is a general misconception that is there. We can protect one part of the game and the other part is not taken care of. So that is very essential that we protect all the aspects of the game and the products that are there. So that is very important. So for that, I think we can have due diligence and IP audits which are carried out very frequently to ensure the protection is there.
All right. One question I have been grappling with is specifically with respect to jurisprudence. We've seen that now games are not installed on your devices, but when you're essentially playing an online game, the games are being hosted on servers which may reside outside your jurisdiction. It may be a situation that the gamer may be sitting in India, the company may be registered in Russia, but the servers may altogether be somewhere in Europe. In these situations, when it comes to IP enforcement, how is the jurisdictional issue primarily addressed? If you can throw some light on that.
Yeah, so it would basically be a question of determining which forum is closest to the matter at hand. Where exactly could the cause of action be traced in such a way that the forum is the most apt or most suitable for taking up the matter? So where the defendant resides, where the cause of action arose, in whole or in part, all these are considerations. Other than that, if there are ambiguities regarding probably the position of the server, maybe in a country where it is not possible for India to exercise its jurisdiction, or probably the parties to go and seek relief, or with which we do not have an extradition treaty, something like that. Then another way to determine would be to look at the language and currency that determines that is applicable to a particular game. So various aspects, and primarily I think it should fall based on cause of action. Where the cause of action arises in whole or in part should be the one factor to determine which court has jurisdiction regarding such disputes.
All right, so I have been told that we have already exhausted the time. Maybe if we have 2 minutes, we can take a couple of questions from the audiences, if there are any. Otherwise, we can, yes, please.
We have been deriving from the current laws in order to determine whatever disputes have come up before the honorable courts. So we derive from the various intellectual property legislations to protect any instance where there is an infringement of a particular IP, maybe a trademark or a copyright or design or patent, whatever it is. But then the need of the hour is a separate set of rules, because the space is fast growing, and that necessitates greater regulation and its own separate set of rules.
Yeah, now see, recently I guess even there were a set of rules which were released under Information Technology Act. So it has certain aspect like self-regulating bodies, and the cognizance should be taken promptly within 24 hours, 15. So timelines are provided there. But see, basically issue will come only with regard to jurisdiction. If it is only with regard to IP, laws are in place. But the issue will come like because of jurisdiction, because games are released worldwide. So I have servers at multiple locations, I have players at multiple locations. So according to me, with regard to jurisdiction, there has to be consensus at the international level that in such cases, how the issues will be handled. With regard to the need of law, I think present laws are there. Of course, it will evolve because this is something new space that is coming up. So it will take time, but laws are sufficient, but a jurisdiction will be major concern in near future.
Thank you. If there are no more questions, I think we can end the session.
To illuminate your path forward, a warm thank you to the distinguished panelists for their dedication to excellence in today's conversation. A big thank you to the experienced moderator for facilitating a seamless, enriching discussion. We'll have a presentation of mementos. Mr. Ankur Garg.
I'll take a compliment.